Thank you very much. Welcome, everyone, to the House Committee on General and Housing. And today is Thursday, February 13th, all day. And it is almost 10:50 in the morning. What we're going to do is hear this morning, we're not going to hear it, we're going to have introduced to the committee and then a walkthrough from our council, just explaining what the bill is and what it does briefly. This is not a hearing to take testimony. So I think, you know what, given the number of people in this room that I don't recognize, despite the fact that the author of the bill is a member of the committee, I'd like the committee introduce itself.
All right, Emily Crosnow, Chittenden 9, South Burlington.
Saudia Lamont, Lamoille, Washington District.
Elizabeth Burrows, Windsor 1 District.
Debbie Dolgan, I represent St. Johnsbury, Concord, and Kirby.
Tom Charlton, I represent Athens, Chester, Grafton, and Wyndham.
Joe Parsons, Newbury, Thompson, and Groton.
Mary, would you like to introduce yourself? Mary?
You're just the kind
Introduce
of.
yourself.
Hello, I am Mary Howard. I represent Rutland District 6.
Bueno, bienvenidos todos. Gracias por su asistencia. Okay, take it away.
Introduce yourself, Chair.
Oh, I didn't. I'm Mark Mahaly, and I represent Calais, Plainfield, and Marshfield, and I'm the chair.
Right, for the record, I am Rep. Leonora Dodge. I represent the best parts of Essex Town and the city of Essex Junction. And I'm here to introduce H-169, which is a bill that, when we talk about what are the problems that we're trying to solve, the real issue for us committee-wide is retaining our workforce. And this is one path to making sure that the very people that are helping us build ourselves out of our house shortage have access to housing themselves. And so this bill tries to resolve that by fighting the common challenges that immigrant workforce Vermonters face when going into the rental market. And facing discrimination based on their migratory status. Again, yesterday we heard worst case scenarios of tenant situations, and so this is also a bill that is trying to, shed light on the worst case scenarios that a lot of immigrant Vermonters face when looking for housing. Many are limited to substandard or risky employer-provided housing situations. We've seen a lot of those when those things go really badly in the news recently. And so the bill does two things. It amends statutes to protect renters in general from having to share their social security number on rental application forms. And this is something that several other states have deemed that it should be an optional and not an obligatory practice. And the other thing is that the bill does is adds immigration status to our protected categories list in our Vermont Fair Housing and Public Accommodations Act. And the benefits, I would say, is that this is a pro-housing and a pro-privacy bill. It requires zero state dollars. It prevents identity fraud, and by protecting the privacy of Vermonters' social security numbers in general. It respects the rights of landlords to request other forms of government ID. And it aligns Vermont with several other states that have put similar protections into statute. And then finally, it helps our contractors. As we've all heard, workforce seems to be the primary obstacle that many of them are facing when all the regulations and even the state and federal funding is on the table, there's still a challenge. I would say that We have, I believe it is 43, including the 3 co-leads on this bill, which are myself and Coach Christie and Esme Cole. We have 40 other co-sponsors, including some members of our committee, and many endorsing organizations in the state. Asylum seeker service providers, migrant justice, a lot of the offices that, like the community action offices, including CVOEO, are behind this. The ACLU, our Office of Racial Equity, and our Commission for Human Rights. So a lot of people want to move in some direction, and so we've come up with language from last year. This was language that was done by Vermont Law School legal experts in immigration who did research into what other states had done, and we are trying to put this measure into Senate language as well in their omnibus housing bill. But I love the way that our committee works and the way that we get to dig into stuff. And so that's why I thought it to bring this to our attention and to bring it up in our wonderful committee. So thank you.
Thank you, Lenore. Much appreciated, and I'm glad you were able to present the bill to the committee. Cameron, are you?
And I was wondering if we could,
Yes.
I'm sorry, can you repeat how many other states have similar bills or
So,
laws?
yeah, so what I can tell you is that Washington State and New York State have added immigration status as a protected class in housing and public accommodations.
Okay.
Illinois and California prohibit landlords from threatening or taking action against their tenants based on immigration status. Minnesota requires landlords to accept a tax ID number instead of a social. And Alaska and Guam have restricted collecting social security numbers. And Guam actually requires that any solicitation for a social security number include a statement as to whether the individual is legally required to provide it or whether this is an optional request.
Thank you.
Lenore, you were saying, Leonora?
Yes, I had asked if somebody from the community, because this really was a community grown bill, originating bill, which I think is great. It's not just something that I thought up in the middle of the night, like some of our other bills that, you laugh because it's true. But this was really a grassroots effort kind of a bill, similar to our driver's licenses, regardless of migratory status, and our tuition equity, regardless of migratory status. And so I thought it would be really important just from the start to make sure that this isn't just my face presenting this. This is
Right.
a
Well,
lot
I
of,
certainly understand that, and we understand from what you said that that's the case. This isn't a hearing on the bill, so
Sure.
we're not taking evidence on the bill at this time. So it's just a walkthrough.
Yeah.
And then we'd have to schedule a bill for hearing,
okay,
including whether you, as its author, wish to amend it in any way ahead of time in response to communications that you are having from other individuals who have thoughts on the bill.
right.
Anything you can do to address concerns before it actually is heard just makes it that much quicker and easier.
Absolutely. And I would say that folks wanted to come to kind of show the support that's out there. Obviously, that's coming through. And also to to make themselves available to folks, even after, throughout after this brief walkthrough.
Right, and we will have a little time for that.
Yeah.
Thank you so much. Cameron, you want to come and walk us through the bill? For those in the room who are not familiar with our process, this is a chance for Cameron is one of our legislative council, and he is the person charged with the drafting, the final drafting about this bill. And it's our custom that even before we take testimony or consider the bill in detail, that we have a walkthrough. And the walkthrough means that our attorney just takes us through the bill in some detail. Cameron, you want to state your name for the record? And
Absolutely. For the record, Cameron Wood, Office of Legislative Counsel. Good morning, everybody. This is my first walkthrough back in this capacity for the office. So, as you guys may remember, when I introduced myself or when we first met, I clerked for the office around 10 years ago. And so it's my first time back here in this role. So little nerves, right?
Oh.
No, you all are great. So
Have some candy.
I'll also start just by, categorizing, as I've mentioned to you all, this is new subject matter area for me. For the past 9 years, I've been with the Department of Labor. So that's kind of my primary background. So just understand that if you have questions that I may not be able to answer, my role and how I operate is I'm not going to give you an answer if I don't know the answer, or I will qualify my answers if I'm not 100% sure. And, obviously happy to take your questions back and do any additional research and come back to the committee. So just wanted to mention that at the outset as well. I'm pretty sure this is still my 7th week on the job. So anyway, yeah, I think, Representative Dodge did a good job of kind of walking through the bill. If you all have it or need it, it is available
We have it up
electronically
on
on
our
our committee page. So just to kind of briefly take the committee through the language itself, we have here on page 2, section 1. This is in the chapter related to residential rental agreements and prohibited acts specifically. And so what this would do is, as you can see, it's an amendment that would prohibit a landlord or a landlord's agent from requesting a social security number of an individual or a member of the individual's household in order to apply to enter into a rental agreement for a residential dwelling unit or conduct a criminal background or credit check. And then second, it's adding a new subsection at the end of this section, subsection C, which will state that if it
I
is,
got to interrupt you and just ask.
Yes, sir.
A minute, sorry.
that's okay.
So this says a landlord can't ask for a social security number in order to conduct a criminal background check or a credit check. It doesn't say they couldn't otherwise conduct a criminal background check or a credit check if they can. I mean, we'll wait testimony if there's an issue there, but
Yes, sir.
it doesn't prohibit conducting a criminal background check. Is that right?
That is how I read the language.
Or it doesn't prohibit a credit check.
Correct.
It just, they can't demand your social security number to do it. Okay.
Yes. That is how I read the language. It is you cannot request a social security number in order to apply to enter into the rental agreement or to conduct the criminal background or the credit check.
Yeah.
So it would not, from my reading of this language, and if anyone has concerns, be happy to listen to that and research and address and come back if appropriate. But my understanding of this reading is it would not prohibit you as a landlord from doing a background check
Right.
or a credit check based on other information that you are requesting
Right.
from the tenant.
On its face.
Yes, sir.
We'll have to take testimony if we hear this on the question of whether one can do those things without the social
Correct.
or how you do them. Okay.
Okay.
Thank you.
So again, top of page 3, line 3, we're in the new sub 3 that's being added. So again, this is prohibited acts. It's saying that if it's required during an application process, then a landlord shall accept an original or a copy of any form of government issued identification. So it's not mandating that ID be provided. It's not mandating that a landlord ask for it. It's not prohibiting a landlord from asking for it. It's saying that if you are asking for it, you have to accept an original or a copy of a form of government issued ID.
What is, you may not know the answer to this question. If required during the application process. If what is required during an application process? What's intended here?
If identification is required during.
Identification is,
Yes, sir.
okay, thank you.
Okay, section 2, we're still on page 3 here, line 6. We're moving into, we've moved out of the chapter related to residential rental agreements. We're now moving into the chapter associated with Vermont's Fair Housing and Public Accommodations Act. So here's where the state has articulated the protections that we provide to individuals in public accommodations and housing. And so here we have in the definition section, there's a definition of harassment. This, I believe, has been added. I can't recall, some of the committee may remember. I know this was moved last year, but I think it was added a few years ago, this definition of harassment. I know last year, or in 2023, the committee moved it over to the definition section. But under the definition of harassment, we're adding, and here's the most of the remainder of the amendments here are specific to line 15 here on page 3, where we're adding citizenship and immigration status into the categories of protected classes for all of the protections that we have in public accommodations and fair housing. So most of the remainder of these changes, and I'll walk through them very quickly, are just going to be adding those 2 categories into those protections, citizenship and then separately immigration status. So you can see it here on the definition, and then, yes, sir.
So just to clarify for everybody in the room, the way, because not everybody has this up in front of them, this would mean that, I guess, harassment is, in the public accommodations law, harassment is prohibited, right? As it is defined.
And it's specifically called out, I believe, in the fair housing piece. You cannot harass individuals.
Right.
Yes.
So to harass means unwelcome conduct that detracts from, undermines, or interferes with a person's use of a public accommodation or any of the accommodation advantages, facilities, privileges of a public accommodation because of, and then ... immigration status.
Correct.
And citizenship. All right, thank you.
Right.
Go ahead.
Can we, just because it's not my specialty, or can we give some more definition to immigration status? Are we talking about documented immigration status? Or talking about undocumented immigration? How broad it is?
So I've seen language in the past and in others that provides a definition of citizenship and an immigration status. I did not include that in the bill here because I wasn't sure that it was helpful. Some of the language I've seen just says citizenship or immigration status is,
Is it
is
defined
being
elsewhere?
or lack of US citizenship. And I found that to be a little bit circular. It didn't make sense. It's not defined, but I think, broadly speaking, citizenship is going to be whether or not you're a citizen of the United States. So it would cover individuals who would be undocumented. That is a citizenship status. But it would also cover individuals who may be citizens of another country. So as I was discussing this with some of my colleagues, one of them pointed out, for example, just taking some of the, current scope of what's going on in global politics, this would protect somebody who may be Ukrainian or Russian, for example.
So I'm just anticipating the questions around, does this protect undocumented immigration? Does it protect illegal immigration?
So I guess I would respond this way. It's not going to have any impact on the macro of illegal immigration, as I think you may be thinking.
I'm thinking specific to how.
Specific to in this bill, the public accommodations in the state of Vermont and fair housing, it would prohibit an individual from discriminating against someone if they were an undocumented immigrant.
That's
Illegal immigrant, illegal, and I want to be careful with the terms. I'm not sure what the, appropriate term is, right? But yes, to get to your question, those, if you are not here,
Is there a situation in which there would not be some other form of government issued identification? Would that indicate anything along? I mean, they'd have to be
Say that again.
documented. So I'm looking back at the
Mhm.
beginning of the bill.
Mhm.
If required during the application process, landlord's agent shall accept an original or copy of any form of government issued identification.
Mhm.
So what I anticipate being asked is that would indicate that there is some legal status, immigrant status. But I think that where there's going to be some pushback in the community is, does this protect people that are coming across the border with no documentation and not doing illegally? This is the question I know I'm going to get asked. Just make it sound intelligent for the answer.
Yes, I would say it will.
if they have ID.
Right.
Government issued ID, doesn't have to be US government.
Right.
I think that's a reasonable reading of it. It is not limited. Yes, the language itself, I think an argument could be made that it is not limited to US government issued ID. So if you have a passport, for example.
Nor,
So I was also just going to say that this actually also protects actual citizens, full citizens, because this is also based on perception, right?
Right.
So if somebody is simply being discriminated against because they're perceived to not have, US citizenship.
Well, if they do, then it's easy to establish.
Well,
So this way we can
yeah.
establish it ever.
Although citizenship and other levels of documentation, there's a spectrum, right? And so if we're basing whether you can afford to live somewhere and that you don't have a criminal background check, that should be all that a tenant needs, or a landlord needs to know, right? Otherwise, you're making a whole bunch of other assumptions just simply based on the fact that, well, maybe your parents brought you here when you were 5 years old and you've grown up here, but you didn't even know that you didn't have citizenship because you just grew up, right? Like that's very common in this country. And so, you might have no criminal background, but you also do not have a piece of paper that says that you have US citizenship.
is, I think, a question that will be asked, and perhaps you should be prepared to answer, is whether the extent of protection in the sense that if the bill allows a landlord to request some form of ID that's government issued, if I am an undocumented immigrant, an illegal immigrant, I've come across the border and I'm doing great work here in Vermont. Can I get government ID? Can I get a Vermont driver's license? I can.
Yes, yeah. And in fact, many people, just to clarify, because I've heard it a couple of times and I hear it outside of committee as well. So let's just to level this out. Many of the people that we are terming as illegal immigrants have, yes, crossed the border and asked for asylum.
Right.
And that is not illegal.
Right.
Yet.
So there's those there.
I think
So that's
Yeah.
just to clarify that there are many people who Vermont readily welcomes and needs to retain, who are quote unquote doing it the right way. The
Yes.
problem is that doing it the right way is lengthy and uncertain, and I liken it to trying to play hopscotch where people are erasing the squares and you're trying to throw, instead of like a little stone, like a burning ember.
I'm
Like,
not,
it's very, yeah, so just wanted to clarify, because
right. This
because
is,
there's a lot of reasons why somebody would not have documentation, and it has
100%.
nothing to do with whether or not they would be good tenants.
right. This is, as I understand it, and because we're trying to focus on the meaning of the bill and responding to Tom's question. Citizenship means, are you, what country are you a citizen of?
Yeah.
I think that while it's defined in some places, in many other places in statute, immigration status is a term that is used without definition. And I think it's because it is understood to mean it doesn't matter whether you are seeking asylum, whether you are in process, whether you have a green card, whether you are a completely illegal immigrant in the sense that you've entered the country without any sort of permission and are doing wonderful work here in Vermont, of which there are many. All of that is immigration status. And that the bill as it is designed would still allow any of those people to avail themselves of housing or public accommodations as long as they have some form of government issued ID, and that is requested of them.
I would concur with the chair.
All right, thank you.
And just to clarify, government issued ID in Vermont is actually very easy to get, whether or not you're undocumented, because you can get a driver's license, you can get a tax ID number, you can get a non-driver's ID as well. So we
Great.
do have alternatives.
You had a question?
No, I was just gonna make a request I think, just until we can move on, but as we go on in the conversation and things come up, if we could switch to the language of undocumented versus illegal, I would prefer that. That would make me feel better.
Right.
And I don't want to, God, bring them in, we need the workforce. What I'm anticipating is a little bit of apprehension from renters about that small percentage that are crossing the border that really are a problem. And there's no way of discerning. So that's the anxiety at the other end.
Oh,
And trying
I
to figure
hear you.
out.
I'm just saying this for language purposes.
Yeah.
Like reprimanding me.
I'm just saying for language purposes.
She's.
Not a concern, concern is valid.
She's
Language
saying I'm
purposes.
being politically incorrect, which is fine.
Just legally inaccurate.
Exactly, exactly. That's all it is.
That's all we're trying to
All
do.
right, would you go ahead?
Okay.
Thank you, sorry.
No, you're right.
Heard, yes. I would concur with the chair's statements as far as it goes with the definitions of citizenship and. So again, we're in the definition section. We've got it added to the definition of harass. And when we move to page 4, the next section, we're moving into the section specifically related to public accommodations. So we have, an owner or operator or a place of public accommodation cannot discriminate against individuals, and we're adding citizenship and immigration status. They cannot refuse, withhold, deny those individuals any of the accommodations, advantages, facilities, and privileges of the place of public accommodation.
I would only add for the committee that I've dealt elsewhere with the public accommodations law. And you should understand, it only applies to places of public accommodation.
Correct.
So places that can argue that we don't want the public in are not covered by this law.
And then we're moving into section 4. We're on line 14 of page 4, where we're going to amend each of the relevant sections of the Unfair Housing Practices Act. So this, and again, these are all prohibitions against actions of individuals. So these are not mandating actions, right? So the language itself here, going back to a conversation we were having a second ago, doesn't mandate that you rent to anyone. It's saying that you as a landlord cannot do these. You cannot discriminate against individuals based on these status. So sub 1, you cannot, and I'm gonna be somewhat brief. I'm not gonna read this necessarily line by line here. But I will just touch on each of the sections. You cannot refuse to sell or rent, or refuse to negotiate for the sale or rent. Now we're moving to the top of page 5, sub 2, line 4 here. You cannot discriminate against or harass. So this is why we have the definition of harassment at the beginning. So you cannot harass in the terms or conditions, privileges, and protections of the sale or rental of a dwelling. Moving into the sub 3, you cannot make, print, publish, or cause to be made, printed, or published any notice, statement, or advertisement with the respect to the sale or rental. So you can't have, advertisements that say, we don't rent to, undocumented individuals in this case, or we don't rent to individuals of a specific citizenship. Just sticking with the example I gave earlier, we don't rent to Russian individuals, could be an example. Moving to the top of page 6, the sub 4. So again, prohibited acts to represent that a dwelling, and I'm skipping to line 6. So to represent that in a dwelling or other real estate is not available. So trying to dissuade individuals from applying for a rental application by telling them it's not available. Sub 6 here, page 6, we're on line 10. You cannot discriminate against a person in the making or purchasing of loans or providing other financial assistance for real estate related transactions. In the sub 7, we're on line 18. Prohibited from engaging in blockbusting practices for profit, which may include inducing or attempting to induce a person to sell or rent by representations regarding that entry into the neighborhood of a person or persons of these protected categories live there or intend to occupy that dwelling. We're on page 7, sub 8. You cannot deny any person access to membership or participation in any multiple listing service, real estate brokers organization, or other service relating to the business of selling or renting dwellings. And then on sub 12 here on line 16, to discriminate in land use decisions or in the permitting of housing because of these protected classes. And then the last subsection here is going to be on page 8, which is adding a subsection D, which is saying that the provisions, so all of those prohibitions that we just walked through, will not preclude, or they shall not preclude, the verification of immigration status if required by federal law. The one piece here I will say to the committee, and I mentioned this to Representative Dodge the other day, in kind of talking with one of my colleagues, who some of you are familiar with, Damian Leonard, who used to be in this committee frequently and has walked through some of these provisions in the past with the committee. He gave me a really good recommendation on that subsection D to kind of reword it, to phrase it a little bit better, to clarify that. Just to clarify what the intent of the language is. I think it's relatively clear the way that it's written. If it's required by federal, law or, a federal grant to verify immigration status, you're not breaking the law under this section if you're doing so. But there is a way to kind of reword it a little bit to just make sure that that is specifically clear. It wouldn't be changing any of the language necessarily. It's more of taking the conditional statement and moving it to the front.
Are you familiar with the federal laws which would require identification and verification of immigration status?
At this point, no, sir, I would not feel comfortable talking about
But I'm hoping that at the moment, federal laws may require verification, but they don't require discrimination yet.
There was another question I got, just that maybe a question that, some of you are thinking about. We already protect race and national origin, and would these things not be, included within that? And in the limited research I've been able to do, I haven't found a court that has specifically decided that question. And so, there is nothing prohibiting you all from being more explicit about the instances that you're trying to protect. So, a court could come in and say, that is not covered. Undocumented status is not a protection of national origin. I've also imagined the scenario where someone may be discriminating against an individual who is, from a Latin American country and they bring a claim saying that you're discriminating against me based on my national origin. And then the individual says, no, I'm not. I'm discriminating against you because you're undocumented. And so, I think there is an argument to be made to have them as distinct protections. And just also know, I should have kind of commented on this in the very beginning, but the Vermont's Public Accommodations and Unfair Housing Practices Act, they work in conjunction with the federal law, Federal Civil Rights Act, which also have similar protections, and Federal Fair Housing Act of Public Accommodations as well. Vermont's list of protected classes, over the years, we as a state have decided it's appropriate to add additional protected classes here in Vermont. But, just know that a lot of this is also works in conjunction with federal protections for these classes as well.
So what you're saying, what you're saying, just to be clear, is you're saying that we have the legal right to pass a statute like this if we so desire. And that the fact that and whatever we may think of the effort overall, it's not necessarily redundant of federal law that prohibits discrimination based on race or national origin, because immigration status may go beyond.
Yes, sir.
Thank you. Are there any questions? Yes.
Well, I mean, this just has to do with applying for a rental property, right? I mean, this isn't like the signing of the lease. This is all before the signing of the lease.
I don't know if I fully understand your question. There is a specific prohibition in the unfair housing practices. This is, page 5. You can't, harass a person with terms, conditions, privileges, and protections of sale, rental, or other real estate. So I would say it goes beyond that in that it protects individuals who are currently being housed from a landlord harassing them
Okay.
after they've subsequently moved in because of
they've
one of
already-
these
Okay.
statuses.
Well, I mean, when you know that the Servicemen Civil Relief Act, which is a federal program, does require to fill out that form, it does require a social security number.
So this is another concern that kind of has been raised that I am aware of, and I will let the committee know that this is a topic that I have not had the opportunity to do exhaustive research at this point in time. My understanding is the Service Member Civil Relief Act is intended to ensure that service men and women and others, service people, are protected from, civil action and other financial implications in the event that they are active duty and have been deployed. And so the way this comes up, my understanding, frequently the way this comes up is if you're taking an individual into court. So for this context, if you are taking someone into court because of an eviction proceeding is where I'm assuming this would most frequently come up, or as it relates to this, the Relief Act specifically. You, the individual bringing that action, have to, I'm going to be careful and use my layman's terms here, not legal terms. You have to prove that an individual is not active duty and deployed at that point in time. My understanding is the easiest way to do that is via a social security number. I do not believe that it is required to do that through a social security number, but I'm caveating that again by what I said at the beginning. This is the area where I would need to do some more extensive research and come back to you with my comfort of an affirmative statement. But my understanding is it's not required, but it is the easiest method. It is the most direct method of proving that an individual is not an active duty and deployed at the time.
What, Cameron, I think it's safe to say we're, and just for everybody in the room who's unfamiliar with this, this is simply an introduction to this bill. That is its purpose to clarify for all of us, well, what is it? As it currently is stated. when we hear the bill, we will take testimony from anyone who's, it's important and has opinions on the bill and have opportunities to ask questions. Then, if we hear the bill, we would bring it to the committee where people could express their opinions, decide how they want to vote. I think it's safe to say that there are certain areas, Cameron, which I would call quasi-legal, where people are going to turn to you in part, even though other witnesses might be able to. But I think a question like, does that serviceman's law, does that as a practical matter or as a facial matter allow other forms of verification? And would a landlord be protected if, I don't know. I don't know, but I think that's gonna come up and you might want to know more about that. I think that you may want to look into, although I imagine witnesses would testify to it, things like how does one engage in a, going back here, how does one conduct a criminal background check or a credit check without a social security number? Those are important. Those are so, I don't know, such important and basic issues. You, Cameron, might get asked, or the committee may ask you those questions. And I imagine we could have testimony on that issue from other people as well, but I have a feeling you won't get scot-free by saying, oh, well, that's not a legal question.
These are things that I need to learn over time, so it gives me an opportunity to do so.
Thank you.
Claudia.
So just one clarifying question, statement, however you want to do it, just to clarify. Essentially, what this bill intends to do is it's the social security number aspect, right? Is the new portion, and then it's addition to protected class.
Right.
Right. So this is, it's already public accommodation law and fair housing laws. And we're just looking to incorporate and expand our protected class for that, for discrimination purposes. So to prohibit discrimination, and then the social security number, and to explore other ways of using documentation for, I think you said privacy. That's the summary, right? Because we just had a long conversation. Okay.
Yeah, we could have
Thank
saved
you.
a lot of
You
time.
did a great job.
I'm like, okay, help me
Tom?
nail it down.
So for people listening, I just want I want them to know I'm co-signing the bill. I want this to succeed. That's why I'm asking these questions.
I love that.
Thank you.
Fine.
That's why this is a tripartisan bill.
A question that we probably want to answer here. This goes, will this go before Commerce at some point?
Oh, I don't know.
Okay. On page 6. Line 10, we're talking about providing financial assistance, real transaction loans. A mortgage lenders might not be comfortable with.
We actually have
Is that
a representative of mortgage lenders enjoying the proceeding right now. So rest assured that whatever their concerns are,
Okay, that's the, this, it just occurs to me, and I'm not a lawyer, so someone will have to translate. Citizenship and immigration status, as we look at this list of protected categories, these, unlike the others, have more legal implications than creed, color, sexual orientation, marital status. So they're, I don't know, in terms of what rights and responsibilities you have on the ground in the US. And I'm not a lawyer. I'm not an immigration specialist. This is, to some degree, this is contingent on legal status in the US. The others are not.
Are you returning to your earlier point that you might feel more comfortable if these terms were defined?
The citizenship one question, I understand, but then whether or not a person is a citizenship of anywhere is a legal question for some entity somewhere to determine. Right, whether it's a foreign country, this country, whatever, that's a question of legal status in some sovereign state. Immigration status is this world in between that doesn't have as much definition.
I mean, I
And
think it
it's-
does, but I think
so-
it could be defined.
Okay, maybe for purposes.
I mean, I think you're hearing at least one member of the committee is telling you that they are not comfortable without a definition of this issue. Not that he stated whether he'd vote, which way he'd vote on it.
No, I'm
but he's just-
anticipating that this might be where someone.
And so you might want to, you said at the beginning, Cameron, and you thought this was gonna be easy, right?
No.
You said You said at the beginning that you were under the impression that immigration status was a term, a legal term that is used elsewhere in statute and not defined, and that it was therefore okay to do that. And that you thought that in other places it was defined. You might want to run that down.
What I'll do is I'll check our own statutes and see. I've seen it defined in other states. I'll check with internally if we have defined it. Yes, I will check and come back. To me, it is, in my opinion, and I think a court will easily understand what immigration status means. So I would, if you can define it, the committee can, work on a definition if you so choose and put it in and then limit it or expand it in the way in which you want it defined. I will check and see if our other statutes have defined it and maybe bring it back and when the committee takes the bill up again, if you take it up again and just
Thank you.
kind of, we'll walk through that a little bit.
Great. I do anticipate, Tom, that if, this is just hypothetical, if it's true that it's never defined in statute, that it means what it means. In other words, that immigration status is the basic term. And if it's not defined, there may be some hesitation to take on defining in this one place, because then that would have implications throughout all our laws. But I don't know yet. They'll tell us.
I mean, I'm thinking in terms of like, if you had to define what people mean by gender identity, like there's scholarship, years of scholarship and publications about what that is. And
We'll find out.
it's sort of, yeah.
It's by interpretations.
Yeah, right. I understand. This is what you're hearing. Are there any other questions by members of the committee? Cameron? Yes.
Well, and I think I just want to say that this is specifically about, this is not changing the laws of who gets to have citizenship, or anything. This is strictly about making sure that people are on a level playing field when approaching a rental opportunity and giving people recourse, a leg to stand on if they are being discriminated against based on what somebody perceives is their immigration status. And I think we can, if we just keep it to that understanding, it's a lot easier to imagine the situations that we would be in. It's not like we're changing, your tax status or giving you documentation that you wouldn't, like we're not interfering in any federal laws. And I mean, I think that's why other states are adopting this, is because our states are the battlefield where we can actually take up this issue of protecting people who otherwise are increasingly facing hatred and just baseless discrimination. There is no reason to assume that because you don't have clear immigration status, that means you are have a higher tendency to be a criminal or to not pay your rent or to destroy property. I think that's what we're trying to protect people from, people assuming that is going to be the case, to just jump to that worst case scenario and just say, I don't want to deal with you. And the reason, it makes economic sense. It makes obviously civil rights sense, but in our state, we are seeing that the workforce is not just living hidden on a farm. There's a growing need for people in contracting, in hospitality, et cetera. And so that's why the timing of the bill, the need for some kind of measure.
I think that,
I just want to say, as chair, I'm going to play chair here.
Yeah. And so,
I am, remember, we are
That's what I
not
was
hearing
about
the
to
bill,
say.
we
Yeah.
are not hearing the bill here.
it's getting.
I
to-
did, I did accommodate, you said, because it was under the idea that the author has a right to clarify their intent. But generally speaking, we will have a time to advocate. If we take this off the wall, we will have a time to advocate for or against the bill.
Yeah, that's what I was gonna say. I feel like this is getting to a point where this is not becoming a walkthrough anymore, and we
Yeah.
have to be respectful
Right.
of that process, and there'll be time if we take the bill up to go deeper, but it's getting a little bit.
Right, okay. Any technical or questions of camera that haven't been asked? Thank you very much. And thank you very much to everyone who has come on this issue. We are going to
He's gonna
next, please, everybody, do not embarrass this committee. We are going to have a joint hearing with the House Committee on Commerce. And it's going to be in room 267 of the pavilion, which means room 11 must have been booked or something like that.
Thanks.
I know.
Everyone's like,
Yes, McDonald.
I think those things are generally better set up to
Upstairs.
accommodate 22 representatives.
Someone
Whereas,
says that
as you might have noted, there are some constrictions.
Yeah, well, it's a lot of, and we have to move a lot of furniture around, and Magali ends up being one of the people moving the furniture. Okay, so room 267 at 1:00. Please be a little early, don't be late. It's hard when I notice that everybody from the Commerce Committee is there and we're kind of